I'm here on behalf of the appellants. Could I reserve 5 minutes rebuttal, please?
That'll be fine.
Your Honor, this is an interesting case. It's a water runoff case that had been going on for years and years and years and years. There's a couple things that I want to address to the court that I think is interesting. In the beginning, there is absolutely no proof in this record, zero, of any proof of damages by the plaintiff. None. What there is a ruling by Judge Sharp, who I have the utmost respect for, where I can only characterize it respectfully as him being an advocate for the plaintiff in this case. He awards $20,000 in emotional damages in this case. The unfortunate part about that is emotional damages were never pled. Zero. There isn't.
Counsel, do they have to be specifically pled?
I think it does. I think you have to show that there's some kind of an emotional juxtapose for us to address it. I mean, we didn't address the issues of, and I don't want to get into it, but it's in the record that this gentleman had all kinds of pre-existing anxiety issues, which we could have addressed had it been brought up. The judge sua sponte just ruled he's got $20,000 in emotional damages. No reason for it, no analysis. That's just what he ruled. And I think, yes, we have to be put on notice of that to address it. The second thing in this case that's interesting is that this issue, and I know you gentlemen have studied the pleadings, but this issue about this continuing nuisance. The judge, I'll read from the order from Judge Sharp, entered on, put my glasses on, entered on November 24th.
Emotional damage, the only issue of damages that you're contesting?
I'm sorry, sir?
Is the emotional damage, is that the only issue of damage that you're
No,
contesting?
sir. The judge has ruled in his last order, and I'll read it. It says, further, the court finds that prior findings should not be modified and that the defendant shall pay whatever it takes to reasonably clean the plaintiff's pond. What does that mean? Well, the way I read this is that he's obviously, the court, Judge Sharp, is obviously saying that this is a permanent nuisance.
Well, and if it can be remedied at a reasonable cost, then it's not a permanent nuisance, right? And if it's repairable, if it can be repaired reasonably, and then it's temporary, isn't it?
How do we know that?
Well, I'm curious about that. Mr. Brown offered, let's call it unexpected testimony in this case, in terms of amount, in terms of what should be done. Was there any contemporaneous objection made to Mr. Brown's testimony? I think he said 50,000. It could be a couple 100,000. That's a decent sized range. But was there any contemporaneous objection made?
Absolutely. The first thing, and I guess the old adage, no good deed goes unpunished. My dear friend over here requested that this gentleman be brought in to testify from North Carolina, I believe. He'd never been to the property. He'd never seen it. He still hasn't seen it. But Judge Sharp starts asking him questions about, well, what would it cost to debride this property? Out of the blue. I had no clue this was going to happen. And I don't think my or the adversary did either, because we both agreed that this gentleman was not calling to be called as an expert. But then Judge Sharp starts asking him about how much is it going to cost. I mean, what am I supposed to do? Question Judge Sharp? He asks the questions, and then the gentleman says, well, $100,000. And then he poo-poos that, Judge Sharp, and says, I don't know what it's going to cost. But here I am sitting there fat, dumb, and happy with this new issue that I've had no opportunity to address.
Is that the only evidence in the record that relates to the reasonableness of remedying, if it's in the record? I mean, in terms of, maybe it's appropriately, maybe it's not. But
Thank you, Your Honor. I don't want to misspeak. Is that in the record? The only thing that we have in the record is where Judge Sharp starts asking him questions about what's it going to cost to do.
So there's no other testimony that says you can dredge this pond or lake and it's going to cost $75,000 or $100,000. There's nothing else in the record that.
Your Honor, as I remember, I hope I'm speaking correctly, there is some inquiry about what fluorocarbons are going to cost. I learned more about ponds than I'd ever want to think I would learn about it. There's an issue called turbidity. Turbidity means, and our expert spoke about it, all ponds, all of them in the East Tennessee area are turbid. What that means is these particles they stay suspended in the water indefinitely. And our expert said, you can treat it till the cows come home, but it's still going to be there. And that's important, because the whole issue is this issue about the muddiness. My adversary here started calling it muddiness, when there were issues when this issue about the turbidity came up.
I take it the part of the pushback here for that position is there's between, TDEC and some of the expert analysis, that there's a fair amount of discussion of remediation, right? I mean, in terms of you can do this, you can do that, you can do this other thing, and it's helpful to some extent. And is part of the analysis essentially pushing back that, well, and we have experts saying you can do these things and therefore they're reasonable to be done, because the experts are saying these are things that you can do, and TDEC says, hey, you need to go do these 10 things. They're presumably telling you 10 things that are reasonably feasible to be accomplished.
And I think that's a great point you bring up, but here's the problem. You can't remedy it. Turbidity happens every time it rains. Every time, without exception. That's clear and unequivocal in this record. So every time it rains, this is going to happen.
Well, there was proof to the contrary, wasn't there? I mean, that wasn't the only testimony before the trial court on that, was it? That's what I understand. That's what your expert said.
I'm unaware of any other proof, Your Honor.
What about testimony in here in terms of the condition of the lake pond before and the building project? I mean, there's pictures, different coloration, that then we all of a sudden have dirt piles up the hill, and that we've got changed composition of the water. I mean, isn't that evidence of change, essentially?
Yes, and you bring up another good point. This debridement had been going on in this pond for 48 years. It's coming down from the hillsides, not by our doing, but by the plaintiff's doing. And as that continues to happen, the debridement grows.
But when the plaintiff presents evidence saying, hey, it used to be this beautiful body of water out there, it was wonderful to look at, and then all of a sudden these developers came along and there was a dirt pile up the hill and it comes running down because they're not using proper erosion control mechanisms and methods. And isn't that isn't that evidence that, I mean, you're saying it's been going on for 48 years and it's leaves and it's twigs and it's all that other stuff, and isn't there contrary proof in the record that, from which the trial judge could have, I mean, the trial judge is the fact finder, said, hey, I think that was the cause.
There's a picture, I believe it's Exhibit 6 in the record, which shows what this pond looked like before our paw prints were ever on it. And it's filthy. It's filthy. And it's in the record, Your Honor, please. And you're bringing up some great points. And it looks like am I out of time, Judge Sweeney? My thing is on there.
You've used your time. You have your time for rebuttal.
Thank you.
Yeah. Hear from the appellee.
Good afternoon, Your Honor. I'm Franklin Chansey on behalf of the appellee, Leighton Lippert. There is one thing that both sides agree on in this case, and that is the most important testimony before the court comes from Mr. Alan Ogles, who's been referred to as an expert, but he was actually the designated representative for the defendant at the trial in this case. Accordingly, the plaintiff called him as a witness as part of our case in chief. And what Mr. Ogles testified to was the process that's applicable to a development of this sort. Specifically, there's a permitting process with the Tennessee Department of Environment and Conservation, and steps that the developer is required to take. And Mr. Ogles was hired by the developer to, 1, plan out erosion control for this site, 2, to monitor it, 3, to make recommendations for how you address it as the project moves forward, and to make reports to the Tennessee Department of Environment and Conservation. He did those things. He created a site plan to control erosion in this case. And as part of his role, he would go out and do multiple inspections a week to see what happened. And his reports, and these are all exhibits in the trial record, demonstrate him identifying failures or problems in the erosion control. It's not his responsibility to address those, it's the developers at that point. And those reports that he did all say on the next one whether the previous ones have been addressed or not. And time and time and time again, his own reports say previous deficiencies not addressed.
Counsel,
here's a new problem
let's
we've
say
got.
we, for purposes of argument, let's say you're right, let's say that there's causation, there's adequate proof of causation, that this pond has had increased sediment, further discoloration as a result of improper practices by the developer. What evidence was properly before the court that addressed the cost of remedying this problem?
Well, in the complaint, we asked for a mandatory injunction to remedy the problem. And that's the way I interpret the court's order. It was not, you go pay a specific amount. It was, you go take the steps at whatever cost that might be to remedy the problem.
In drawing a distinction, the opposing counsel pushes on this statute of limitations variance between temporary versus permanent, right?
Sure.
And so to be temporary, doesn't it have to be remedial at a reasonable cost or expense?
This is a very important distinction, Your Honor, and I'm glad you asked that question. There's two things happening here, and the appellants want to conflate them into one. The first one is there's an accumulation of sediment in his pond. That's what that question goes to. The second one, though, is the aesthetic effect on the pond that occurs visually when these rain events occur. And those are separate things that we're talking about, and you can't treat them as one. There are pictures in the record where you actually see this caramel color following a rain beginning to spread out across the pond. It's not uniformly changing color all at one time. You actually see it moving across the pond until it makes the whole pond this caramel color. Mr. Ogle testified that the discoloration of the pond, and I'm quoting, following a rain event was primarily from runoff from the B and D site. the runoff was the single biggest cause of the caramel discoloration. That's what was causing the emotional upset for my client in this case. It was visually, he had this pristine Walden-esque property that was being affected by
All
that.
right, so we have, you're saying there are two things here. There's the continuing runoff prevention, and there's sediment that's currently in the pond that would be dredged out. Does the injunction embrace both of those?
I think it requires two different actions.
Okay.
One is,
How much does stopping the runoff cost? How much does dredging the pond cost?
well, Mr. Ogle, I don't have a specific dollar amount for stopping the runoff. What Mr. Ogles testified to, though, was that there was the possibility of increasing the retention pond size. They could create a spillover pond. They could put baffles in the pond. They could increase their use of flocculants. They could put additional silt fences up that would be properly maintained. They could do check dams.
Do you disagree, counsel, with that understanding that that Tennessee courts have essentially, and correct me if I'm wrong, I could be wrong on this, the Tennessee courts have taken the position that, if given all time and all money, you can remedy anything. So to remedy it, it has to be reasonable. Otherwise, it becomes permanent, and then we run back into that statute of limitations issue in this case. So if there's no evidence in this record as to how much it cost, and one of the two things that we're talking about in terms of all time, all money are cost and amount of time to do it.
Well, some of these things are very minimal.
How do we know that, though?
Well, there was some proof in a record about how much bags of flocculant cost, for example. That's one of the steps that Mr. Ogles indicated could be done, and that was a few $100s.
The injunction goes well beyond buying a couple bags of that. I mean, it also includes, it seems to include dredging, it seems to include runoff prevention.
Two separate issues, though, Your Honor. One is an injunction to take the steps on the developer's property to stop the runoff that is causing the discoloration. That's number one. The second one was, and there's a report from Mr. Brown that went into the file, into the record, which shows that there's two major accumulations of sediment in this pond. One's out in the middle of it, and one is right at the foot where all this stuff's flowing in here. And that's what the court limited its ruling to, which was removing the sediment there that's in the pond. Not the whole thing, just part of it. So the court was attempting to limit the impact of its order.
Do we have any idea how much that cost, though? Did the trial judge have any idea how much that cost? So let's take the
Well,
dredging. So dredging that part of the pond. Is it $1 million? Is it $10 million? Is it $1,000?
Well, that range that you got was for the whole pond. The court limited it from that, so it would be a lesser number than that.
That's when you say the range. You're talking about Mr. Brown's testimony.
He said that 50 to 200 range, but that was for the entire pond, and the largest accumulation of sediment was out in the middle of the pond, which the court did not order them to.
Is Mr. Brown's testimony properly, when he says 50 to a couple, is that properly, is it properly before the court in terms of considering? So if you're trying to figure out whether there's a dollar figure here to determine reasonableness, is that properly in evidence or not?
Mr. Brown was the designated records custodian for the company that did this report, and he was out of Missouri at the time he came. So he came from Missouri about this. And the defendant objected to that portion of his report that had cost in it, that he wasn't an expert. So that estimate in and of itself was not put in the record. Mr. Brown, when asked by the court, though, then gave this range that was based upon the total cost of the pond.
Was there any contemporaneous objection made to that testimony?
Not that I'm aware of, Your Honor.
Okay.
Yeah. Now,
Counsel, let me just, maybe you address it briefly, the $20,000 for emotional damages.
Yeah.
Was there anything in your complaint about asking for emotional damages?
yeah, the complaint asked for compensation for injury to the use and enjoyment of the property. Enjoyment by itself is a ambiguous term, but I think it includes the reasonable enjoyment of the use of the property in this case, and that's what was affected by this ongoing discoloration issue. My client talked about how upset it made him every time he saw it. There was a period of time in the year before the trial when he was undergoing chemotherapy for cancer and so forth, and it was very upsetting that he didn't have this pristine area that was calming to him. So I think I can give you an example of an analogy for this. In wrongful death cases, it's the pecuniary value of someone's life, but our courts have said, well, that includes things like loss of consortium and parental consortium and so forth. Well, I think that this emotional upset is consumed in use enjoyment of property. And I think that's a reasonable interpretation. And the cases that we've cited, the Dye case, they all talk, the Fink case, all talk about the fact that this is one of the elements of damage in a temporary nuisance case because it is loss of enjoyment of the property. There's many ways to measure damages in a temporary nuisance case, but that's one of them. And I don't think there's any requirement under the law that that be pled specifically.
Is there any reference in the complaint to the emotional aspect here in terms of are there facts asserted that say he was talk about his emotional effect, the emotional effect this had on him?
No,
Okay.
it says he's being deprived of the use and enjoyment of his property. That is the way we phrase that. Now, they're objecting to this order by the court that they correct this problem where sediment is accumulating at the effort there. And their objection is they don't have a specific dollar amount. So respectfully, if the court were to find that that's an appropriate issue on appeal, then I think the remedy there is to send it back to the trial court to make that finding.
At one point, we have 3 different orders here, right? And the diminution in value was at one point part of this. Is that gone now? Is that no longer part of the award in this case?
Well, the court did not make an award for that amount.
Isn't there in the initial order there's a appraisal and so that's struck though, right?
But
I mean,
we did not appeal that issue.
Okay, you didn't appeal.
So-
but you're not asserting that that's still part of the. Okay.
That's correct, Your
All
Honor.
right.
That is correct. Does the court have any additional questions?
I hear none. Thank
Thank
you.
you, Your Honor.
Hear from you, Taylor, rebuttal.
Very briefly, Your Honor. In terms of an objection, we filed a motion to strike their expert testimony. We objected to it adamantly.
Do you have to renew that so we have here, let's say, I think that if I'm remembering correctly here, the trial judge basically said, let's see how this goes in this case with regard to the expert. The trial judge then asked the question in terms of, well, how much would this cost? And do you have to say, Judge, we object to that, to the inclusion of that evidence in order to preserve that, or is that evidence now in?
I was faced with that dilemma of calling Judge Sharp out, and rightfully or wrongfully, I didn't. I mean, I was taken aback when, and I love Judge Sharp, I was taken aback when Judge Sharp started asking him questions about what's it going to cost to fix this?
The dollar figure that's referenced by Mr. Brown, is that just related to the dredging, or is that related to the dredging and the erosion control runoff stopping components, or not sure?
I'm not sure,
Okay.
and that's part of the problem. We get this amorphous opinion, which doesn't instruct us about how to do anything, and they knew about the problem in this pond on. Make sure I got my dates right. December 6, 2016, because they complained about it to TDAC. Ad nauseum they did. They didn't file this complaint appeal until March 11th, 2020. That's over, the 3-year statute has run. And the problem we're dealing with here, and Judge, you've hit it right on the head, we don't know how much it's going to cost to fix this. We don't know if it can ever be fixed. That's the problem. It is a, you know, to use a cheesy analogy, if it waddles like a duck on a pond, it's a duck. And this problem, let me read something real quick. I apologize, I'm rambling a little bit. This is from our brief on page 6. Mr. Ogle also testified that the measures currently in place used by the defendant to address the runoff are working as designated to the satisfactory of all governmental agencies involved. He says that. He says pond turbidity is to impound every drop on the defendant's site, which cannot be done. That's what he says. We're sitting here with a dilemma that begs for an answer in terms of remediation, and it's unquantifiable. Thank you for your time.
Of course, thanks to both counsel. We appreciate your arguments and your briefs on this. If you would, please adjourn court till our next regularly scheduled docket.
All rise. This honorable court is now adjourned until the next term of our docket. Thank you.
All have a good afternoon.
Thank you.